Alright, so this is just We the People News. This is part two, people. Okay, I'm gonna make this a little shorter and sweeter. Alright, however, I still gotta do this, okay? For YouTube purposes. Okay, this video and me is not attorneys. We're not giving legal advice. Okay, this is educational purposes only. Whatever we say or do not take it as legal advice. Okay, um, I don't think there's any more I need to say about that, right? All right, let's proceed forward on this distinctions between attorney and counsel. What is it? And people out there, by the way, when you do your document of family courts and all that, um, it does not hurt. Now, they may argue with you, but you tell them with your offspring, not child, people. Child is a person under 18, okay? Read the statute on child, okay? It's under the corporate umbrella, believe it or not. All right. Anyway, okay? You tell them you are the offspring's counsel. You've been counseling from the time of the beginning, and you plan on being his counsel until your end to give him directions how to be an honorable man and women through life and teach them. You know, you're their counselor. You're teaching them how to drive. You're teaching them how to do the schoolwork. You're teaching them to be this. You're doing this and this and this. You're counseling them through life. Counsel is just not for these lawyers, okay? Where they're doing business. They give out counsel. So let's not be one-minded, right? Never look straight forward. Always look around you. Be able to protect yourself by any means necessary. People, people, people.
Entitled to the assistance of counsel at law, and that while there are many, and that while there may be attorneys at law in Alaska, there are no counselors at law. The terms attorney and counselor originally did have differing meanings. Y'all pay attention. Just pay attention. This is where they're going to start breaking this stuff down. Some of y'all already may know this stuff, but I thought this was a really, really good case. I didn't even read all of it. And I'm not going to read all of it in this video. I would advise you to, though. Both words come from Old French, the language spoken by the Normans, who conquered England in the 11th century. See how they're going back in time, telling y'all what's going on? The word attorney first appeared in Anglo-French writing in the early 1300s. At that time, the word, at that time it was written attorney or attorney, attorney, or whatever, something like that. This word is the past participle in English, the ed form of the verb attorner or attorner. The verb attorner literally means to turn to, in the sense of turning to someone for aid or assistance. It then came to mean to turn over to, in the sense of entrusting one's affairs to another person. Thus, by the time the word showed up in Anglo-French writing, attorney or attorney meant to assign or appoint someone to act as your agent or representative for any purpose, not just lawsuits. And the word attorney, what is that? Attorney, whatever you say. It looks like seems like it's some type of French word, if I'm not mistaken. And the word,
just in case you can't read it, ATURNE with a little, I can't even think of that word now. Okay? So, check that out.
Attorney meant the person who was assigned or appointed. And then they have a footnote in here. Let's see. We still use the word attorney in the broad sense when we speak of giving someone a power of attorney to transact business or make decisions on our behalf. And the person to whom we give a power of attorney is called an attorney, although we use the phrase attorney in fact, because nowadays the word attorney standing by itself means a legal profession. Okay. In early English law, a private attorney was someone who was appointed, usually hired for pay, to act for another person in any sort of business, including but not limited to legal affairs. On the other hand, a public attorney or an attorney at law was a person who was licensed to represent people in courts, but not represent in the full sense that we would understand today. That's interesting. An attorney at law could investigate and prepare cases for court and could attend court proceedings as the personal representative of the person whose interests were at stake. But the attorney could not actually plead the case, i.e., could not participate as an advocate at the hearing or trial. That job was assigned to the counselor. So this is who this guy is asking for. Or counsel, the legal professional, now known as a barrister in England. This is getting good. The word counsel used as a noun rather than a verb comes from the old French counsel, which meant a plan or opinion. Thus, a counselor was a person who formatted a plan or rendered an opinion. I can agree with that. Again, we still use the word counselor in the broader sense, but the word also came to mean a professional legal advocate, a person who was versed in the law and whose profession was to plead cases in the courts. So I'm not a lawyer. I'm a counselor. So you're not a lawyer, you're a counselor. So this is why they say the right to counsel. So obviously, whoever drafted the Constitution intentionally used the word the right to counsel to omit attorneys from trying cases in there. It seems like that's what happened to me. The terms counselor and counselor, used in this sense first appear in Anglo-French writing in the late 14th century. The common law distinction between attorney and counsel is described by William Blackstone in his commentaries on the laws of England, first edition, blah, blah, blah. There it goes. I need to find that book. Let me see if I can find that and read that. And I'll try to do a video on that for y'all. It is also usual in the superior courts to have attorneys and advocates or counsel as assistants. By the way, that footnote right here is telling you where you can find this stuff. The complete text of the first edition of William Blackstone's commentaries is available online from the Yale University Law School's Avalon Project. I wonder, is it free? I'm going to try to find it and see if I can read that. An attorney at law is one who is, well, I probably don't need to read that. Y'all already know that. I'm gonna skip down. I'm gonna let y'all. I think I read the most of the good parts. So I don't want to bore y'all with all of that. But I am. Which one is it? It was something. I think it was. Was it down here? Yeah, well, it was a little bit more. This is kind of long. I don't really want to bore y'all. Because, well, they do mention some more cases that also draws the distinction between them. So I might just read y'all that part. And then the end of the passage that I wanted. So I'm going to start back right here. Sorry about that, y'all. In the 18th and 19th centuries, the word attorney became a term of contempt in England. So much so that Parliament abolished the term in the Judicature Act of 1873. Thus, in England, the people who performed the traditional roles of attorneys at law are now known as solicitors. So I wonder why were they so contempt with that?
So when you hear England on your videos, like if you cop watch or anything like that, people over, when they say I'm a solicitor, now you know that they are an attorney. Okay, so when they say I'm a solicitor, but the downfall is they changed the name, but they're still operating within the same process, right? If it's a quacks like a duck, it walks like a duck, and it looks like a duck. It's a freaking duck.
Word in England. That's very interesting. These are some footnotes right here. Y'all can read those if y'all want. I'm going to stop right there and let you read them if you want to. And I'm going to scroll down. However, the term attorney survived in America. Originally, in American law, the word attorney had the same limited meaning as, under the English common law, personal representative. This older meaning is illustrated in an 1833 opinion of the Pennsylvania Supreme Court, Mercer versus Watson. So if you're in Pennsylvania, here's the case. You can go and read that.
Which is funny because maybe, just maybe, all the attorneys in England moved over here because they found out that, hey, we got these states selling their sovereignty, and we could make a bunch of money getting we the people to comply to our whim. I don't know, people.
Let's see. Parties are technically and properly said to appear in suits by attorney and not by counsel. Counselor or counselors are terms familiar to the law. The province of these professions is not simply to appear in actions as the personal representative of the party. Rather, it is to conduct the suit by their advice and advocacy through all of its progress. And in the difficult emergencies nowadays, we would say developments or contingencies of a trial by jury and of arguments before the court.
Now, just so you guys know, this is a box, okay? So this, even though you read this in court, this has no weight right here in court. It's basically a note, okay? And when they did this and this and this, basically what they did is took it out. They boxed it in. And when they did that, they kind of pulled it out of the document, separated it. It's the 4 corner rules.
I'm gonna start back right here. Let me see I gotta see if I'm wrapping this up because I don't want to read too much. Yeah. Okay, so I'm gonna start back right here. No, right here. I'm gonna start back right here, and then I'm gonna go down to probably about 2 to 3 more paragraphs, and I'm gonna stop there, and that'll be the end of this video. Nevertheless, even at the time of Mercer versus Watson, the line between attorney and counselor were blurring in the American legal practice because the same legal professionals normally performed both functions. As indicated by the passage from Blackstone and as indicated by the Pennsylvania's court's opinion in Mercer versus Watson, both attorneys and counsels at law were regulated and licensed by the government. Moreover, the opinion in Mercer versus Watson shows that by the 1830s, American law had already departed from the English rule described in Mercer versus Watson, the rule that the office of attorney was completely separate from the office of counsel. So that was a rule in England that they were separate offices, but they departed from it here, which they can do that because they're sovereign. But I just wanted to, I want to point this stuff out to y'all. The rule that...
Now they're saying that, and I may be wrong, I'm not an attorney, all right? But the judicial system really actually kidnapped from really the legislature. Now they still do it and adopt it, but the judicial system actually has done a lot of changes in these processes themselves. Unlawfully, in my opinion, unconstitutionally, in my opinion, but the whole thing was unconstitutional in the process.
The office of attorney was completely separate from the office of counselor, and that no counselor or barrister could take on the role of attorney without first resigning his office, asking to be disbarred. Let me read that again. And that no counselor or barrister... Okay. I see what they're saying now. Rather, in America, or at least in Pennsylvania in 1833, counsels are always attorneys, and under our rules, members of the bar are admitted to practice either as attorneys or counselors. Let's see. In fact, the Pennsylvania court noted that the formal procedures that distinguished attorneys from counselors were breaking down and falling into disuse. The court discussed the fact that under Pennsylvania law, a counselor who was also functioning as the attorney in a case, that is, a counselor whose client was absent from court, so that the counselor was performing the double duty of legal advocate and personal representative. So basically, if I understand this correctly, an attorney is just a personal representative that was delegated certain duties to him, like he was delegated to handle personal affairs, basically. And counselor, they would actually argue the cases before the court. It seems like that's what they're saying in here. If I'm wrong, y'all let me know, but it seems like that is exactly what they're saying here.
And again, I'm not an attorney, but I believe, my belief, right? The counsel was there beside you, not to argue for the judge. You are to speak, but the counsel is there basically to hold your hand. And say, okay, you need to bring up section 222.12 to the judge. And then you'll speak and say, hey, we need to look at the section 222.12, you know. But the counsel was sitting there beside you, helping you working through the process. Then again, I could be wrong. I did not live before 1800s.
I'm gonna start back right here. The court discussed the fact that under Pennsylvania law, a counselor who was also functioning as the attorney in a case, that is, a counselor whose client was absent from court, so that the counselor was performing the double duty of legal advocate and personal representative of the client, was supposed to file a separate document, a warrant of attorney, what we would now call a power of attorney. Okay. Remember, it doesn't matter what they call it. It matters its substance over form. It doesn't matter the title of the document. It's always substance over form. That attested to the fact that their client had appointed them to be their attorney. In the narrow sense of the word, despite the existence of this law, the Pennsylvania court acknowledged that it is not the practice and never has been in this state for counselors at law to file warrants of attorney. And yet they still receive their fees and speak for their clients without their authority ever being questioned. That's interesting. The merging of the two roles of counselor and attorney continued in America to the point where today many legal professionals would be unable to correctly describe the common law distinction between counselor and attorney at law unless they performed legal research of the sort described above. But for purposes of resolving the arguments raised by Crane in this position, the important thing is that as a matter of Alaska law, the term attorney now encompasses both meanings. I'm going to stop right there. This is a really good case. I haven't read it all yet, but I think they really go down into the details of it. I think this is a really good case. If y'all want this case, you can go and read it for yourself. I think this was really a really good breakdown of it. I'm not sure who this so-called judge was or whatever, but it seems like it was a man and he did a really good job. Let me see. Crane and propria persona Wallace for the petitioner. He did a really good job explaining that. Really good job. So this is the case citation again. If y'all want it,
All right, we're going to end it there. Yeah, I'm with him. It was an interesting case. Words do matter. All right, do your own research, people. Okay, and argue your case and make sure you're in the right venue. I agree. They did a fantastic job on this. But they still distinguish one and the same when they cannot be one and the same, in my opinion. Not legal advice. Okay? This will be the People News. Till next time. Bye, y'all.